Hey, thank you very much. That's fine. Sit down. That's already. So,
I think okay. I think I believe we can start. Uh, Good afternoon, learned colleagues. My name is Tola Oshobi. I welcome you on behalf of the chairman of the MBA Institute of Continuing Legal Education to the 2024 edition of the MBA ICLE Civil Litigation Training. This is the second edition of the Civil Litigation Training. We had the first edition 2 years ago, and it was well received by our colleagues. We are commencing this session. This is the first session today, and this is the first session of this series. The training is going to go on for about 3 weeks, and it's going to run from Wednesdays to Fridays on every week from 3 p.m. to 5:30 p.m. We're supposed to have 2 sessions every day, and we have a very strong panel of a very strong faculty to anchor this training, and we hope our colleagues will take take advantage of this and benefit. The way the session, we have our very first speaker today is Mr. Ibrahim Sule. He's a very eminent professional colleague. He's currently the director of academics at the Nigerian Law School, Kano campus, and is a fellow of the International Bar Association. He had his master's degree from the University of Birmingham, UK, and I hope you can hear me. Birmingham, UK, and has 5 different international practice diplomas from the College of Law, England and Wales. Oh, sorry, am I? Hello? Can you hear
we
me?
can hear you, sir.
Oh, I'm so sorry. I think I had some technical issues, but I will just go again. I was trying to introduce our first speaker for this training series. As I said, I'll just run through that again. I'm so sorry. My first speaker is a very eminent professional colleague, Mr. Ibrahim Sule, who is currently a director of academics in the Nigerian Law School Kano campus. He's a fellow of the International Bar Association. He has a master's degree in law from the University of Birmingham, UK. and 5 different international practice diplomas from the College of Law, England and Wales, now University of Law, London. He's currently pursuing a PhD in electronic lawyering at the University of Utara in Malaysia. He has interest in the intersection between the legal profession, ICT, internet, and AI. He has numerous publications to his credit in both local and foreign journals. Ladies and gentlemen, please welcome Mr. Ibrahim Sule. Before I hand over to him fully, I just want to mention that the first session, each session is for 1 hour. The speakers have a discretion how they want to structure it. It's usually 40 to 45 minutes of presentation and 15 to 20 minutes of Q&A. We would implore the colleagues to post their questions in the Q&A column, the Zoom link Q&A, so that we can, after the presentation, one of the members of the organizing team would read out the questions so that our facilitators can answer them. I think we are good to go. The first topic for today is dealing with the pre-hearing stage, taking instructions, evaluation and analysis of instructions, managing client expectations, and just basically a lot of housekeeping issues, which are very important. It is not just the job of a lawyer to take instruction and then grab his pen or computer and start drafting pleadings. A lot of things that go into preparing a case or preparing for a case, or taking instruction, understanding the instruction, evaluating the facts and the issues, and so on and so forth. So without further ado, I will just hand over to Mr. Ibrahim Sule to proceed with his presentation. Thank you very much, sir. Thank you very much, everyone. You are muted, sir. You need to unmute, sir.
Oh, thank you. Is that okay now?
Yes, it's clear. We can hear you and we can see you too.
Oh, okay, that's great. Thank you so much, sir, for this introduction. Let me go straight ahead to share my slides, because I have about 26 slides and I have 45 minutes to go through them. I hope I can do that. Let me share the slides. Just trying to. I think the slides are here, if you can see them.
Hello.
Okay. Okay, great. My noble lords, the distinguished learned colleagues who have joined us, a very well good afternoon to all of you. I have been asked to talk about five issues. One, about taking clients' instructions, about evaluation of instruction, analysis of the client's instruction, managing clients' expectations, and then finally, preliminary matters. And I understand one thing, that if we are going to talk about these 4 or 5 things, especially the past 4, i.e. taking clients' instruction, evaluation and analysis of clients' instruction, and how to successfully manage clients' expectations, we are obviously expected to talk about client's interview and counseling, because it is in the client's interview and counseling that we do all this. It is in the client's interview and counseling that we take client's instruction, that we seek to evaluate them, that we effectively also seek to analyze them, that we try to also pinpoint areas on how to successfully manage our clients' expectations, and then how to pinpoint certain preliminary matters that we must consider before venturing into litigation. That's why I coined my presentation to be client interview and counseling, some strategies and protocols for Nigerian lawyers. And I'm going to talk about the following items, if time permits. Firstly, for us to successfully take clients' instruction and evaluate and analyze them, we have to understand the meaning of the interview as far as legal profession is concerned, because we do conduct interview in many fora, in social fora, in our families, in our workplaces. We do conduct interview, but all these types of interviews are quite different from lawyer-client interview. And I'm going also to talk about how to have a successful interview. And doing that will take us to understand some phases or stages of interview. And then I will talk about counseling. I will talk about importance of listening, because majorly that's what we do in client interview. You can't take client's instruction without listening to him. You can't properly and effectively evaluate or analyze client's interview without listening to him or without questioning him. So I'm going to talk about questioning skills. Towards understanding client's instruction very well, we have to understand the body language and some facial expressions of the client, so that we understand what he means from his body language, even if he has not been able to tell us. And I'm also going to talk about briefly on how to manage clients' expectations. And then I'm going to outline some preliminary issues that we have to consider for us to successfully handle our clients' instructions, either in litigation or in ADR or in any other manner. So what is client interview? As I have said it, we have been interviewing,
Sorry to interject, sir.
Yes, sir.
Sorry to interject, sir.
Yes,
The
sir.
slides are not showing. They're a bit blurred. I don't know if that's from our technical people or from your
Okay,
end.
they're a bit blood.
They are blurred. So we can't see the slide.
Okay.
I'm sure some of our
let me reshare it again, sir.
Okay, thank you, sir.
Let me reshare the slides again. Let me stop sharing. I reshare again.
Okay, sir.
What about now, sir?
It's yet to come up, but it's opening gradually.
Okay.
Yeah. We're just waiting for it to open fully. It's not open.
Okay.
It's not.
Okay.
Still not open yet.
Okay.
Maybe you should go on. I just want to assure our delegates that the slides will be circulated.
What about now, sir?
This. It's still not. It's not opening. I don't know what the problem is.
Okay.
Yeah, it's just a narrow line. The full slide is not open.
Okay. So should I continue or should I wait?
Go ahead, sir. Please go ahead, sir. If it comes up later, fine. If it doesn't, then we're going to share the slides anyway to all the delegates subsequently,
great,
and they will be available at the IMBICLE website so that people can access them.
Go ahead, great, sir. Great, sir. Thank you so much, sir. Okay, thank you. As I've said, lawyer-client interview is quite different from any other type of interview that we normally conduct in our life. And that's why I think we have to have a working definition. And I said Client interview is a process by which a lawyer elicits information from his client. All that is a personal communication between two or more people for the practical purpose of obtaining information or instructions. So, client interview, as far as legal profession is concerned, is an opportunity whereby a lawyer would have a sort of a personal communication between him and his prospective client in order to practically obtain certain information and get instruction from the client for the purposes of using the information or the instructions he has gotten from the client to solve the client's legal problem. To solve the client's problem. So, in essence, client's interview is not emotional exchange. It's not an opportunity for a lawyer to exchange some emotional conversation with the client. It's not a social conversation. It's not for social conversation. It's not an opportunity for him to argue or to debate with the client. The lawyer is expected to make use of the opportunity to extract information, to personally communicate and understand the client very well, so that he will have opportunity of solving the client's legal problem. And in a client interview, we obviously have legal practitioners and the client. Sometimes we may have two or more legal practitioners, two or more, two or more clients, depending on the complexity or the nature of the client's problem. And sometimes you may even have some representatives of the client, especially if the client is a corporate organization. And in a complex case, for instance, we may as well have some other professional or experts joining the client, because all what the lawyer is expected to do is to use the opportunity to extract information and to get the client's instruction to use them to solve the client's legal problem. So, as far as our profession is concerned in Nigeria, client interview is a serious business. And in one case, which is in Nnadi and National Air Care Center, and another, the Court of Appeal said, and I quote, from the above cited cases, it is clear that taking client's instruction, executing his services as counsel is not a child's play. It's not a child's play, and it has to be handled seriously because it goes down to the root of our profession. How do we have successful client interview? To have successful client interview is dependent on the impression you give to the client. And why? Because we should always remember that that is the lawyer's first meeting with the client. And we have a saying that first impression matters. So the lawyer must use the opportunity to create a good first impression in the mind of the client, so that the client will be very, very comfortable to say what he would like to say for the lawyer to understand and use the information he gathers to resolve or solve the client's legal problem. So effective interview involves not only mastering the art of speaking to a third party or having good communication skills or knowing the precise strategy you apply. It involves all this, and most importantly, knowing some obstacles to effective interview. There are certain obstacles to effective interview because without understanding these obstacles, one can hardly and effectively evaluate and analyze clients' instruction. So what are these obstacles in client interview? I mentioned just a few. One of them is one must understand or must distinguish or differentiate between his own emotional brain and his thinking brain. Because a client coming to a lawyer sometimes would come in a very confused manner, not knowing what exactly it's going, what he's going to do. And it's for the lawyer to very well understand that he's a problem solver, and it doesn't matter how emotional the client is. He has to use his brain, he has to use his expertise to differentiate what are the legal problems and what are not the legal problems. And there is what we also call client bias. Client bias means, anytime a client comes to meet a lawyer, he will always like the lawyer to believe his own side of the story. And he will always like the lawyer to feel the same way he feels. And that's why he hardly tells him precisely what practically had happened and what exactly are the legal problems. So it's for the lawyer to very well understand this and handle it and carefully. Sometimes there is what we call emotional trauma. It is for the lawyer to try to normalize the trauma by saying what that can make the client to be very, very comfortable to be able to say his own side of the story, and for the lawyer to effectively understand the story, for him to apply the law to the story to solve the client's problem. And sometimes there is another obstacle, which is failure to identify relevant information. Clients are not lawyers, and they don't know what is relevant and what is not relevant. For instance, in a contract, a client may not know what is offer, what is acceptance, what is consideration, what is intention to create a legal relationship. It is for the lawyer to understand this very well and to know what information to gather from the story to identify as an offer, to identify as an acceptance and consideration. Without these, there can be some obstacle on lawyers' part that he may not be able to properly understand or even evaluate and analyze the client's instructions. Sometimes a client may hide the truth so that he tells the lawyer only what he thinks would like to hear. And this will obviously sometimes mislead the lawyer into taking some irrelevant information as important information. And it's very important that a lawyer should understand also this. A lawyer should also be able, from the word go, to understand the purpose of the interview is to establish one, the lawyer-client relationship, is to gather information, and is to learn precisely the client's goals and interests, and for him to determine the next step. So now let's talk about some phases of the interview. There's what we call preparation stage. Preparation stage are things that a lawyer should do or should understand preparatory to the practical interview session. Obviously, before a client comes to a lawyer, he would first contact the lawyer either by phone call or by getting to his office or by WhatsApp now or by Telegram or by any other means. And it's for the lawyer to give him time, dates and location, as well as the venue of the interview. I think it's a good practice if a lawyer gives the precise time that the client would come and meet him in his office. He shouldn't give him a time that he knows he may not be in the office, or that he will be entertaining some other persons or will be engaged doing some other activities in his office. By giving him time, he should make sure that he gives him the precise time that he would meet him and the date. And before the date, it's a good practice that the lawyer should confirm the arrangement before the date. Give him a call to remind him that you have given him a date and time and a location of his interview for him to confirm that he is definitely coming. And another good practice is for the lawyer to enter the time and date in his diary or in his law firm's diary or in his own calendar. And it is going to be a good idea that he will allow or he will make the receptionist or any other person like the secretary to know that somebody is coming today to our law firm to be interviewed, so that by coming, he would be ushered in, and the secretary or the receptionist will at least make him comfortable, so that by the time you start the interview, information will just flow. It's also a good practice that open, given the time and date, to inform the client that you should come with certain documents. Obviously, some clients on calling you by phone or on meeting you preparatory to the main interview will like to brief you, tell you their legal problem. And with that little information, you may know some few documents that you may expect him to bring during the interview session. So preparation to the interview is a good practice that you ask the client to come with certain documents if he informs you of, or if he mentioned them in the course of narrating briefly his own story preparatory to the interview. And most likely, the client is going to come to the law firm, i.e., to your office. Is the good practice is to meet him in the conference room, or if you don't have a conference room or a meeting room, as some law firm do have, you meet him in your own office. So wherever you are meeting him, make sure that the place is very, very conducive, is very, very clean, is free from or free of any clutter, and is in a very non-distracting manner. I mentioned one case in which the Supreme Court said that counsel are not allowed to procure facts in courtroom. So it's completely disallowed that we should be procuring facts in the courtroom. Come what may, we should be able to entertain our clients in our offices, not in the courtroom, please, not in the police stations, not in the client's office, in the client's homes. Looking at what the RPC prescribed or provided, with certain exceptions that I know we all know. And when the client comes, make sure that you don't have files of other clients or other lawyers, so that the place looks neat. It goes to breach the confidential duty on a lawyer for him to allow other clients' files to be seen while he is interviewing other clients. And in this time of digital life, can we record clients' interview? I think yes, but with the permission of the client. If at all you have to entertain him by WhatsApp, for instance, or by phone call, and you want to record him, you should kindly tell him that you will be recording him. I think it's a good practice because it will make your interview very, very effective, because there are some applications that you can install that can convert the audio clip or the audio file that can transcribe it into words, so that you don't have any time to waste to rewrite what you have recorded once again. I have mentioned a few of them in my presentation. I don't have to repeat them again. And what if the client cannot come in person and time is of essence? I think I have talked about this one. And fifthly, you have to make sure that you have what we call client instruction forms. You make them ready. And you also prepare what we call client instruction folder, which is obviously a file containing all the information gathering forms, copies of any relevant material helpful in your interview, and the research you conduct. Because as I'm going to mention in my next point, that you are expected to conduct a preliminary research preparatory to the interview, so that at least you would have an idea. And I believe by the time the client calls you, he may mention an area relating to his own issue that you may have to conduct preliminary research on that area, so that you can also prepare yourself very well for the interview. This happens especially where you get a clue, as I've said, on the area of dispute, and if the client give you the document prior to the interview, you will also be able to review those documents as well, to raise questions on the document and to support omissions, and to look at areas where you would like to have further information when the client finally comes to the interview. And preparatory to the interview, again, you have to make a decision about your fee. And think about how much you are going to charge. It's going to be late for you to start thinking how much you are going to charge when you start the interview. Sometimes you may like even to know the type of the client before he comes, so that you know how much you are going to charge him. You are not telling him how much you are going to charge him preparatory to the interview. No, you are going to make a decision in your mind how much you are going to charge him. This will really help you when you come to make a final decision on your fees. Now, the next phase or stage is beginning the interview, setting the stage. The first thing that you will do when the client comes is to make sure that you make him comfortable. I don't have to say more. But in making a client comfortable, you have to be very, very professional and ethical, depending on the type of the client. Somebody coming to the rural area, maybe to Ikeja for the first time from a rural area, or a woman or a pastor or an imam coming to your office. There are many ways that you can make these kind of people very, very comfortable. And you should think about when you two have a problem and you need someone to talk to you so that he help you solve or resolve your own problem. Think about going to your doctor, think about going to your counselor with their problem. How would you like to make you comfortable? Apply that to your clients. You should also be able to know how to greet your client and how to introduce yourself. In a very culturally and religiously sensitive communities and environments like Nigeria, this can be simple but as well dangerous. You should understand the type of person coming to you. How can you address a pastor? How can you address an imam? How can you address a lady, a politician, and some other higher ranking people? Know how to address them and address them properly. The best practice is to introduce yourself first and allow the client also to introduce himself. Maybe he may like you to call him with all the academic and the political designations, but possibly to make him comfortable. You should do that. It doesn't matter. What matters is for you to make him comfortable so that you gather the necessary information for him to understand his legal problem and the way to resolve them. Chit chat is good, but then you should avoid chit chatting on areas of religion, on politics, and on any other sensitive issue. Chit chatting is maybe likely engaging the client to talk on some other issues like weather, like traffic, and some other things that can make him comfortable before you get into the interview. But one should be very, very cautious that you should never force chit chat on a client who is impatient or who is anxious or who is entirely focused on talking about what brought him. A client may just come to your office in a very traumatic and emotional manner that chit chatting him that way can be dangerous. He may not take you to be serious if you start chit chatting with him. Can someone sit with you at the interview? Yes, somebody can, like your colleague, like your junior colleague, or any person that can help you to take notes of the interview or to record the interview for you or to help you with some computations. If the dispute involves some accounting issues and what have you, yes, you can sit with someone, but that should be with the client's consent only. If he says he doesn't want someone to sit with you, then that should not be done. And open the necessary introductions, open the chit-chatting where possible and necessary. You should explain the purpose of the interview to the client and explain how the interview is to be conducted. Talk about the issues of confidentiality that whatever he's going to say, nobody is going to know about it. It's going to be it's going to be it's going to be a part of your confidential duty that nobody is going to know what he tells you. And you should talk lightly on your fees arrangement. From that time, you would know whether you would have to go on with the full interview, because if he disregards talking about fees arrangement, you know that is unlikely, often spending much of your time, you are going to agree on fees. In Nigeria, we don't charge per hours. In some countries, in Canada, US, even UK, they charge per hour, and they have software that can bill client the moment he gets into the office. So even if at the end of it all, he has not successfully given you the brief, at least you get something out of him because you charge him per hour. But in Nigeria, somebody will come to your law firm with this legal problem. He spend like 2, 3, 4 hours, and the moment you talk to him about this, and that will be the end of everything, and he will go out without you getting anything out of him, though you spend much of your precious time talking with him. I think we should make some amends in our RPC so that in Nigeria we should start charging our clients per hour, because I know our colleagues, all of us have this kind of problem while interviewing our clients. Telling the story stage. That's when the client starts telling his own side of the story. In this stage, or at this stage, listening is very, very important, and you are expected to listen very attentively. You have to be an active and passive listener, and you have to understand the body language of the client, understand his facial expressions, his postures, his gestures, and then you use what you listen, what you gather as you are listening, as you are asking him questions, as you are understanding his body language, to gather the information. And for any information that you don't understand, you use questioning to elicit more information. And it's a good practice for you to use open and close questions. And then open what the client said, we come to analysis stage. That's when the lawyer would use the facts, the story of the client to know the law and the legal remedies. Is going to brainstorm together with the client to know other alternative options. And then you come to conclude the interview when the client might decide to pursue or not to pursue the matter of what you briefly inform him about the case of what you have heard from him. And you may also decide to pursue it because the case has legal merit. So where both of you decide to pursue the matter, you can agree on your type of presentation, you can agree on your fees, and you can also agree on payment structure. It's a good practice for you to confirm the client instruction, open all what he said, open what you analyze. Now you reduce what you understand of his own story into writing, into what we call client instruction. And you ask him also to confirm, so that if there are areas for you to amend, you make the necessary amendment before you finally come up with the client instruction. You can ask as well the client to provide more information or to provide more documents. And while doing that, there are things that you should avoid. I think I have to skip some points because I don't have much time. Now, counseling. This comes after the interview, but not necessarily immediately after the interview. And this is when the lawyer informs the client his own view and opinion about the client's case. And this is usually based on the client's professional and objective judgment of the case. And this is what we call, some writers call analysis. And this is where the lawyer is expected to develop the action plan. And the lawyer is expected also to identify the possible courses he intends to take to solve the client's problem. Is he going to go to court? Is he going to invoke other mechanisms and options like ADR and some other things? Then the client will be left to make independent decision about the courses that the lawyer takes and about the remedies. For open all this, I think we are going. A lawyer is going to successfully analyze, successfully evaluate first, and analyze the client's instructions. But during counseling, meaning during analysis, you should be very, very ethical. Don't be unethical. Don't also advise the client to breach law or to take law into his own hands. Don't also advise him to offer bribe to get any of the remedies that you highlighted. And you should also take note that maintenance and sympathy is unethical, it's not allowed in Nigeria, and you shouldn't agree on anything like that with your clients. Now, I also highlight on importance of listening, because it's very, very important. Listening is just as important as questioning. You use listening and questioning to analyze and evaluate clients' instructions. When somebody comes to you, i.e., when your client or a witness even comes to you, he would probably like to talk and he would be eager to talk about his own problem. And it's your own duty to ensure that you appreciate his own side of the story by listening to him attentively. And the best practice is to use or to apply what we call control listening. Control listening is knowing when to interject and ask a question and when to steer the client or the witness in another direction. You should know when to interject, to ask a particular question, and to encourage also the client to say more of something important as far as the client story is concerned. The best practice is also to, as I've stated here, is to use passive listening as well as active listening mechanisms. Passive listening is when you encourage the client or the witness to keep talking by your silence or by an expression indicating that you should continue. For instance, as the client is talking, you should be nodding head. Yeah, by nodding head, you are passively asking him to say more. You can also maybe use your facial expression to express surprise or shock or something so that he understands that you are really appreciating what he's saying, and that will encourage him to say more. You can say like, oh, okay. All these things will make him will encourage him to say more and will make you understand more of what he's saying. Active listening also is good. It's a best practice. It's when you reflect upon what the client or the witness is saying by a comment or repetition of something he said. You are practicing active listening when, for instance, when the client is telling you the story, you are saying, "Oh yes, okay, go on." And so you are using what we call, or what some authors call, completers. For instance, for you tell him, so your problem is this. So upon what Mr. X said, you said so and so. He will continue to say it more because you are encouraging him to. Or you can make use of what some authors call client recognition and validation. This is that's you practically recognize, that you appreciate what the client said, and you validate what he said as good. For instance, if he says certain fact, you tell him that, yeah, this is good, and I will ask you more about it. This is good information. I like the way you put it. This can make him say more of what more of the good facts you are going to use to understand his instruction, to evaluate and analyze them very well for effective handling. Body language is very, very good. There are many ways that you can understand somebody's body language, and through body language, you can understand a lot of what somebody is feeling, even if he hides what he has in his own mind from you. Somebody looking left and off, he's making what scholars call visual recall. Somebody looking left and centrally, is uh, doing what some authors call auditory recall. He's recalling a noise or a sound. And somebody looking left and down is doing what some scholars call auditory internal dialogue. He's thinking about saying or not saying. He's doing a sort of an internal dialogue between his id ego and super ego, whether to say it or not say it. Looking right and up, he's doing what some authors call visual construction. He's imagining an image, not fact. Looking right and up is an imagination of image, not a fact. Looking right and centrally is auditory construction. Somebody is imagining a sound and not factual. There are a lot of ways that you can understand client's body language, either by his gesture, either by his gesticulation, either by his posture, either by the proximity of his seat, either by the confusion state he comes. There are many ways that you can, a lawyer will be able to understand what a client means, even if a client seeks to hide them. And this will definitely help a lawyer effectively and practically evaluate and analyze clients' instructions. Questions always in the mind of the client. You know, sometimes I can say most often, clients on meeting their lawyers always seek certain answers, and I divide this into three. They normally think whether they can trust you. Can I trust this person? Does this man care about me? Is he going to be committed to my success? You really can not have a straightforward answer to these questions by the time you are conducting client's interview. So don't bother yourself. You can get the answers later. It's your ability to manage your client's expectation that will provide you with the good answers to these questions. But you should always consider these questions so that you can know how to build trust with your own client and how to show him that you are really going to be committed to his own success and you care about his legal problem. How to manage client expectations. First, you should understand what your client wants and why. And this can be done at the interview through listening, through questioning, and through understanding his facial expressions, his gestures, his proximity or seat, and some other body languages that you should understand. Two, you should also be able to carry the client along. You should remember that the client's problem is not your own problem. You are the problem solver. So carry him along so that he should know every bit of information about the way you handle his case. Thirdly, you should have an open discussion with the client about the strengths and weaknesses of his case and the possible outcomes and risk ahead. By being open to him, I believe he would have certain, you would be able to build a sort of trust with him and meet up some of his expectations. Engagement letter is good so that it outlines the scope of your work. He knows how far you can go as far as his instructions are concerned. He knows your fees and the arrangement of payment, and he also will know the expected timelines and the responsibilities of him and your own responsibility. Fifthly, you should keep the client updated as your work progresses and also address their concern promptly. It's a good practice if you can always seek to update the client and give him more information as you are progressing with this work, so that you meet up some of his realistic expectations. Six, you should also be able to educate the client about the legal process, the possible outcome, and the relevant laws. And in this age, most of our clients are well educated. They would first go to Google or go to ChatGPT and seek to know the position of law as far as their problem is concerned and the best way to handle it. And some, before they even come, would have certain idea or knowledge about their own legal problems. So you should also be able to carry them along by educating them more about the legal processes you are going to find and their possible outcome and the relevant law, so that you can meet up with their realistic expectations. You should always avoid giving guarantees of success. Don't guarantee a client that definitely you are going to win this case. Don't tell him that you know the judge. That is unethical. Don't know him that you know the judge's uncle and you are going to meet him. That's very, very unethical. Just tell him that you are going to professionally handle the case and you are going to effectively try your best to make sure that you resolve also his own legal problems and keep him in the picture, so that you will have an idea about the next line of action you are going to take. Now, I'm done with the client interview, and I hope I'm using my time effectively. Now I will get into some preliminary matters. These are matters that every lawyer should consider before venturing into litigation, because these matters are very, very important, that they can help you win a bad case or help you negatively lose a good case. They are very, very important. After the interview, it's not advisable for you to just venture into action by just filing any process in court or by just writing any letter to anybody. There are things that you should consider before you venture into the practical way to handle your client's instructions. One, issue of jurisdiction. You should always understand from the story of your client the connotation of jurisdiction, the territorial jurisdiction, the subject matter jurisdiction, the party's jurisdiction. You should consider the precise courts. That's if you decide to file the case in court. In fact, before you decide, you have to, as I'm going to mention, you have to understand, or you have to ensure that you observe the mandatory duty on you to draw the attention of your client as to the existence of ADR mechanism before venturing into litigation. I'm going to talk about it. First, now you should understand the jurisdiction. Now, you should know the court with jurisdiction from the High Court, Federal High Court, National Industrial Court, up to the Supreme Court. You should also have an idea about their original appellate and supervisory jurisdiction. Not only these superior courts of record, even the magistrate courts, the Sharia courts, the customary courts, you should know and consider whether open the stories you have gathered, the information you have gathered out of the client story, which court would have jurisdiction and how do you approach that court. It's good you consider the Supreme Court's decision in Modukolu, Ikem Dilem, and Galadima and Tambai that highlight on the issue of jurisdiction. And you should also consider, as part of your consideration on jurisdiction, how to ascertain jurisdiction. You can be a lawyer to not necessarily a claimant, but as well a lawyer to the defendant, that the defendant is served with some court processes. You should look at the processes to ascertain whether the court before which the action is filed does have the jurisdiction or not. And you should look at the claim and the relief and the statute establishing the court for you to come to understand whether the court has jurisdiction or not. I refer to Inaya Kaju and Adeleke, where the court outlined this principle. And what to do if there is no jurisdiction? You raise it at any time, and not only at any time, you can raise issue of jurisdiction anyhow, even through irregular processes. In fact, you can raise it orally. It is for the court or for you later to ask to file the necessary processes, but you can raise it at any time. Even at the Court of Appeal or Supreme Court, you can raise it through PO or by motion or notice, depending on the circumstance of each case. And you should ask the court to have the matter struck out. And I refer to Wilbros Nigeria Limited and Akwa Ibom, AG Akwa Ibom State. Secondly, you should also consider the issue of course of action, which is simply a factual situation, the existence of which entitles one person to obtain from court a remedy. It is a legal right by which the breach of which is capable of being remedied, and I refer to Mobile and La Cefa. And on issue of course of action, you should take note of the following. One, you must ascertain the legal basis for the principles of law on which the factual claim is based. Upon hearing what your client narrated in his interview. Two, you should also understand that jurisdiction. And I refer to the case of AG Federation and Abubakar. And if there is no jurisdiction, you can raise it, as I have said it, anytime, anyhow. And thirdly, you should also understand what are the documents that you should look at to discover the issue of jurisdiction. Obviously, as decided in Dada and Awa, you look at the claimant's statement of claim to know whether there is a course of action or not. Just like jurisdiction also, lack of course of action can be raised at any time, even on appeal. And I refer to the Court of Appeal decision in MTN Communications Limited and C Soccer Nigeria Limited. Thirdly, the issue of pre-action notice is very, very important. These are notices statutorily required to be served on the dependent before an action is filed. Some statutes that especially establish some corporate statutory organizations do have prescribed certain notices to be given to those organizations before an action is filed in court against those organizations. And I've cited some examples like Section 26 of 1 of NABDA Act, Section 46 of 1 of the UNIFE Act, and some other statutory provisions. One, you have to understand that non-service of it suspends the court's jurisdiction, i.e., it keeps jurisdiction on hold until it is served. I refer to the case of Nonye and Anyitie. Two, it must be served on the prescribed person. Most statutes prescribe the particular person against whom those pre-action notices are going to be served. You should make sure that you serve to those persons, else it amounts to nothing, as held in the Bodamasi and NRC. And thirdly, its purpose is to give the prospective dependent sufficient time to prepare to deal with the claim so as to avoid springing surprises. Sometime it happens that on servicing the pre-action notice, the statutory organization or the corporate body would engage you to amicably settle the matter. And that's the whole essence of or purpose of service of pre-action notice, so that the defendant is given a notice that until he takes steps to remedy the situation, an action is going to file against it in court. And sometimes counsel can get cases resolved by just servicing pre-action notices, which eventually will help you save time and cost. It is a special defense to be raised timeously. You have to raise it timeously. You don't have to wait until you go on appeal, like unlike the issue of jurisdiction or the course of action. You have to raise it on time. Limitation of action is another consideration. And as we know, sir?
Hello, Mr. Sule. Sorry to interject, sir.
Yes, sir.
So I know we started a bit late, so that's why we've had to readjust. We didn't start
Yes,
late,
sir.
but we had some technical problems. So I don't know if you could round up in about 5 minutes, sir.
Yes, I'll do
so
that,
that we can do the question and answer and go to the next session, please.
Okay, sir.
I've enjoyed it thoroughly, but I mean the slides will be shared with our colleagues. Yes.
Okay,
because we're really getting
okay,
into the meat. I know we're really getting into the meat of it now. Go ahead, sir. Just if you can round up in the next 5 minutes or so, sir.
Oh.
And then we'll go to question and answers.
Okay, sir. Limitation of action is another issue that you must consider, and you have to consider limitation of action because without when you file an action that is started bad, the court will not entertain it. And once an action is not instituted within a given period, the action becomes started bad. Most statutes establishing public corporations or institutions contain limitation of action clause. For instance, under Section 6 of the Nigerian Customs Service Board Act, it prescribes that action against customs must be commenced within 3 months of the course of action. Generally speaking, simple contract cases have to be filed within 6 years of the course of action. Action for damages for negligence within 3 years, damages within 3 years, instrument under seal within 12 years. These are things that you should one should take note of before venturing into action. Issue of locus standi is very, very important. Parties and their capacities are very, very important. Issue of functus officio, whether a court delivers its judgment or ruling on that particular matter that you are seeking to file. It's very, very important that one should consider some of the assumptions in terms of default judgment, stay of execution and stay of proceedings, application for instrumental payments, application to correct clerical errors like slip of tongue, slip of pen, and some other clerical errors. These are exceptions to functors official that one should also consider. Cost of litigation, one should also consider this, and it should weigh the expected gains from a successful litigation against the cost implication of the litigation before filing an action. Issue of ADR is becoming mandatory by virtue of Rule 15 of 3D of RPC and Order 5, Rule 1.3 of Lagos Rules and Order 2, Rule 2, Sub Rule 4 of Abuja Rules. You have to consider it. Enforcement of judgment, you have to consider it. Issue of immunity under Section 308, filing of pre-action counseling certificate.
On the okay. I'll see when I come out.
And then exhaustion of available remedies is a good consideration. Issue of non-justiciability of some actions is also very, very important. On the paper, I've given or cited some reference books to read to know the best practice on client interview and counseling. So thank you. That's the end of my presentation. I have to apologize because I rushed you people, and you can understand that I wanted to effectively use the 45 minutes I was given. Thank you so much for the opportunity. Thank you, sir, for listening.
Thank you very much, Mr. Sule, for your session. It's obvious that a lot of effort and has gone into preparing the slides and to prepare the presentation. It's very comprehensive. It covers a very wide area, even wider than I had anticipated. So we are very thankful. We're also thankful that the slides
Thank you, sir.
Are ready and shared with our colleagues who all those who registered for the conference, and it would also be subsequently accessible even for those who didn't register for the conference with the MBA ICLE. I apologize again for we started on time, but the problem we had a few technical problems initially, and particularly regarding putting up the slides. But so that's why we overshot the time. Well, we did overshoot the time, but we had to give extra time to get as much as possible from the presentation. Thank you very much. So we are question and answer session. My colleague, Mrs. Mabel Okereke, will anchor the question and answer session. I plead with my colleagues, our colleagues, to post their questions in the Q&A box, so that we'll just read them out from there, because it will be difficult to give each person an opportunity to orally ask questions. It will be difficult to choose people. So I implore those who have questions to post it in the Q&A box. I think we already have about 18 questions in the Q&A box. So I'm going to hand over to Mrs. Okereke to conduct the question and answer session. Thank you very much again.
Thank you, sir.
Thank you very much to you, Leonard Silk, and thank you, Mr. Ibrahim Sule. Thank you to all our participants. Very quickly to the questions we have from Mr. Salisu Abdul Aziz Lawal. 1 second. Okay, Frida Odige says, can a defendant raise absence of pre-action notice as a final written address, or is that too late?
Do I have to be answering them bit by bit, or I should take them like three and then answer?
Okay. Can you see them? Do you want to access them, or do you want me to take them out for you, whichever works best for you, sir?
I don't. Okay, I have gone to the question and answer. Okay, yes, I have accepted them, but which of them are you reading?
Okay, I read the one from Frida just now.
Yeah. Can the defendant raise issue of pre-action? Okay.
Hello, I think okay, go ahead. Oh, I thought you were frozen. Okay, go ahead, sir.
Okay. Okay. I think as I've said it, the issue of pre-action suspends court jurisdiction. It keeps it on hold temporarily until it is complied. I think the best practice is for one to raise it timelessly. The moment it starts with the process, he can raise it so that the court would not even waste its time to allow the allow the claimant to comply with that prescription. I don't think it's going to be best option for one to raise it in his final written address. It's like one is crying when one's head is already cut off. Because what will the court do at that time? If the essence is to allow the claimant to go and comply, and upon complying with that, come back and file the process. But I don't know what my learned silk with us are going to say. But that's my view and that's my humble opinion.
Thank you, sir.
I agree with. Okay, go ahead, Mabel.
Hassan says, how does a lawyer approach assessing the legal merits of the client's case?
Okay. How does a lawyer assess the legal merits of the client's case? I think it's very, very simple. One, open considering some of the issues we highlighted at the last limb of our lecture. One will definitely understand whether a client has a good case or not. Is there any court whose jurisdiction over what the client is alleging? Is there any course of action? Does the client have the requisite locus to file the action? Is the action started bad? Some of these things can definitely make a lawyer understand whether the client has a good case or not. If the answer is yes, then he can go on to handle the matter. We should very well understand now our courts have imbibed one tradition of sanctioning a legal practitioner personally when he files a case of an abuse of court process. I can remember recently some of our very respected senior lawyers were personally sanctioned by the Supreme Court to pay some huge amount of money. Why? Because they filed a case which the court considered to be an abuse of court process, a vexatious and a frivolous case. So answers to some of the things we have highlighted can definitely guide someone to understand whether there is merit in one's case or there isn't no any merit. It's not a matter of an academic debate. No, based on the facts and the law, what do you think are you going to do? Is there a court that can effectively handle this case? Is there any course of action? Does he have locus standi? What about the issue of non-justiciability? Is this action justiciable before any court of law? And some other things.
Yeah.
Thank you. This is an interesting one from Mr. Saunders Sampson. Says, sir, now that we don't practice hourly charges in Nigeria, what could a lawyer do to ameliorate the losses that come when spending hours with a client who eventually failed to hire the lawyer when the lawyer's time has been spent without a pay?
I really like this question. And this is very, very tasking sometimes to most of us. But what we do and what I advise people to do is to initiate certain forms for the client to fill out preparatory to the client and ask him to pay for those forms. Interview forms, consultation forms, some other forms that you just have to be innovative in initiating certain forms that a client can fill out and ask him to pay preparatory to the client, so that you don't lose anything, even if at the end of the long story he gets out of your office and refuses to give you the instructions or he refuses to engagement fee.
Thank you, sir. Favor says, what do you do when a client who wants you to do things their way,
for him to fill out again something?
the way they believe should be done, regardless of your advice as a lawyer or what the law says?
We have to eat, my friends. You go out narrating stories and then he later ventures out and then you get nothing and he doesn't allow you to.
I think you need to you run that question again. The question from Favor.
Yes.
Hello.
But it looks like Mr. Sule is offline right now.
Oh, we lost him. Look, I think
Okay.
we have a number of members of the faculty here. We thank Mrs. Funke Adekoya for joining us, Ms. Funke Adekoya SAN, Mr. Sebastian Horn SAN. Thank you for joining us. Although today is not your way, appreciate your presence. I think it is absence. If there are other questions, maybe some of us on the faculty can attempt to answer.
I'm back now.
Okay, he's back. Okay.
Yes, I'm back now. Yes, maybe it's a network problem.
Thank you very much, sir. There's another thank you. Actually, we have a lot of
before the next question, madam. Before the next question, maybe I should beg some of our Ladder Silk and most distinguished seniors to help us engage the NBA to amend our RPC so that we start charging per hour. At least it will help some of our colleagues to get something, even if eventually the client has not agreed on the fees. So I beg you in the name of God to help us amend the rules so that we start charging per hour. Maybe we should start charging decently per hour.
This is noted. We will pass it to who have communicated with the leadership of the NBA. I know there are a lot of challenges to charging hourly in Nigeria, but I'm not sure we have the time to dabble into that fully.
Yes, sir.
Okay, Mrs. Okereke.
Thank you very much, Sule. Indeed, there are lots of appreciation from participants here, thanking you for a good presentation. It was indeed quite insightful. But because the next session is very close, we have Mr. Alimi on standby. I'll yield to Mr. Oshobi SAN so that we can start the very next session. We'll make your slides available to participants, but just very quickly, we'll get into the next session. Thank you very much, Mr. Sule, for your time.
Well, thank you so much, Saz, and for the opportunity given to me. I appreciate. Thank you so much. Thank you.
Before we sign out, hello?
Yeah, go ahead. Go ahead, let us know.
Yeah, before we sign out, I thought my time is fixed for 4 p.m.
No, sorry, let us see. Your session is tomorrow, sir.
Is it tomorrow?
Yes, sir.
Okay.
It's 4 p.m. tomorrow.
Okay.
But we are happy to have you here. We are happy to have you here with us today.
You know, the truth is that I am bereaved, so I think it will give me more time to get ready.
Oh, I'm so sorry about that.
I will still have delivered some goodies, but it's better for me if it's tomorrow.
It's tomorrow, sir. I'm so sorry about, but please
right.
accept our condolences. Yes. Thank you, sir.
Thank you.
Okay. Okay, thank you very much once again, Mr. Ibrahim Sule, for your industry. I knew it was going to be difficult when you said you had 45 slides to run through all the slides, but the material will be available to our colleagues. Thank you for getting it ready in advance. So we will go very quickly to the next session. Again, we're still in the preliminaries, but the preliminaries are always very important in litigation. I always like in litigation to someone who wants to build a house, and there's a lot of work that goes in before you start the actual construction. The architect has to design the house, probably have to get someone to test the soil. You have civil engineering drawings and structural engineering drawings, electrical engineering drawings, mechanical engineering drawings, and a lot of work goes into all that. get building approvals and all kinds of things that you need to do before you go into the actual construction. And these are very important, because sometimes when you get it wrong from the early part, then you get everything wrong. For instance, if you don't build a proper foundation, you cannot build a proper foundation if you don't understand the kind of soil you have built it on, and so on and so many other things. I'm not an engineer, but from the listener experience, so I always likened it to that. So all these preliminaries are very important.
No light this morning.
And I'm sorry,
Light this
let us.
morning.
Oh, sorry. Mr. Adekoya, are you saying, are you okay? So so for the next session, we are going into, we have Mr. Alimi, who is taking this, is Director Academic for the Nigerian Law School Yola campus. In this session, we'll be discussing the necessary processes that have to be filed, and some of the other preliminaries towards the commencement of action. At this point, we're not yet going into pleadings. We have a full session on pleadings for tomorrow, to be anchored by Mr. Eric Obansube, but there are so many other processes that we need to, things you need to consider. For instance, are you, what kind of processes do you want to file? Originating summons, originating motions, writ of summons, all the processes you need to front load. Are you coming by way of petition? What rules of court apply? Is it winding up rules or company proceedings rules if you're in the Federal High Court, or AMCON rules or fast track rules, and so many other things that goes into putting your papers. I said earlier, you don't just grab a pen and paper and start drafting. A lot of thinking has to go into putting your case together. A lot of research. Yes, it's not just research on the substance of the law itself, but research in terms of determining what process, what procedure, and so on and so forth, what rules apply, because we have so many rules. We have a number of practice directions in some jurisdictions that a lot of us sometimes forget. And so we have Mr. Alimi, who will be taking us through some of this today. So please join me in welcoming Mr. Alimi for take us through.
Yeah, with your kind permission, we have a short profile for Mr. Alimi from the NDN.
Please go ahead. Please go ahead. And
thank you very much. Mr. Alimi is a graduate of the Afaniawolowo University and University of Lagos. He practiced with Professor Abiodun Adesanya, SAN, before joining the Council of Legal Education. He's a lecturer at the Nigerian Law School. He's also the Deputy Director of Litigation in the Lagos campus of the Nigerian Law School, and he later became the Director and Head of Litigation Department of the Kano campus of the Law School. He's currently the Director and Head Civil Litigation Department for the Yola campus. He has consulted for a number of local and international organizations on matters relating to administration of justice. He's a co-author and has published several articles in learned journal, mostly on civil procedure and evidence, and he has presented several papers at seminars and at workshops. Thank you so much, Mr. Alimi, for acceding to our request and being here today. Over to you, sir. Thank you.
Thank you so much for the introduction. I'm so grateful for the organizers for the opportunity to form part of this training program. I am sincerely grateful. Now, we will be talking about, let me share the screen. Share, yeah. Planning, as Leonard Sika said, planning is fundamental in civil litigation because a case filed without proper planning is doomed to failure. So, and that is why it's so important to take certain decisions and take some fundamental steps in packaging the case, even before the papers are filed in court. So we'll be going through a number of those steps and decisions that we have to take before we proceed to filing our case in court. First of all, we need to identify the cause of action. We determine the appropriate court. Who are the parties that we are going to take to court? How do we constitute the parties? What is the mode of commencement we are going to adopt? Writ of summons, originate summons, petitions, which one? And then how do we package the originating processes? Because depending on the originating processes, the steps, the packaging are different. So the first issue, let's look at cause of action, for instance. How do we determine the cause of action? From the presentation of Mr. Ibrahim Sule, we'll have seen the facts from the client. But as counsel, it's our duty to make legal sense of the story told by the client. So from our knowledge of the law, we have to decide what area of law do we need to apply to solve the issues involved in the facts supplied by the client. How do we take the matter to court? From the facts, it is possible that we have more than one cause of action, because the same set of facts can give rise to maybe an action in tort or an action in contract. Or we may have to use the enforcement of fundamental rights. It is for us as counsel to decide what is best for the client in the circumstances of the case. We need to merge the facts with the law to decide the best option. For instance, if I engage the services of a building contractor who has done a shoddy job, leading to the maybe collapse of the building, I may have a cause of action in contracts. It is also quite possible to have a cause of action in tort, negligence, for instance. But what are the things that will influence my decision to either go for contracts or go for tort? Or we know anyway that we can actually bring the two causes of action in the alternative. It's quite possible. The rule of pleadings allows for that. And then we need to consider, one, for instance, if I go for contract, what are the remedies available to me? What is the time limit for me to bring the case to court? In the example that I just mentioned now, you have, you may want to come in contract, you may want to come in tort. But if we are bringing the case after 4 years of the accrual of the cause of action, you may no longer be able to come in tort, because the limitation laws of most of our states prescribe 3 years for bringing an action in tort, for instance, negligence. So, but within 4 years, we are still within the limitation period for contract. So those are the kind of things that will influence our decision as to choice of cause of action. And then we must also remember that the cause of action will determine the court we approach. Sorry. This issue involves the issue of jurisdiction of court. We know as counsel that this goes to the root, and as we have heard earlier, court without jurisdiction, whatever it does, is a nullity. We have OBWB and CBN and the rest of them. Now, issue of jurisdiction purely statutory. The Constitution and other statutes have prescribed in creating the courts. They have prescribed the areas, subject matters over which those courts can exercise judicial powers. And anything done outside of those areas will be without jurisdiction and a nullity. A number of courts that share jurisdiction in original civil jurisdiction, we have Supreme Court, Court of Appeal, Federal Court, would examine some of these courts and see the scope of their civil jurisdiction. Before I leave this point, we need to mention the fact that there are possible cases where the course of action may overlap. You may have some subsidiary and major claims. How do we determine which court we approach? The law is that the court with jurisdiction over the main claim should be the court to approach for the case. And it is quite possible when you have your claims that are quite independent, equally important, none is subsidiary to the other. That means the case will have to go to separate court. Each claim will have to be taken to the court with jurisdiction over that claim. In this instance, an NRC, the case involved termination of employment, but the claimant claims that in the process of termination his fundamental rights were breached. So he instituted proceedings in fundamental rights. But eventually at the Supreme Court, it was made clear to him that, right, yes, you may have a case in fundamental right, but the principal issue here is termination of employment, and that is the principal claim. And it is the court with jurisdiction over that claim that should entertain the case. So taking the case to a court based on the fundamental right issue was the wrong step to take. Now, we will go through some of the courts that have original civil jurisdiction. Given our time limit, we may not be able to do comprehensive job, but we try as much as possible to highlight some of the key issues that we need to point out. For the Supreme Court, the original jurisdiction of the court covers 5 items. The entities, federation and state, state and state, National Assembly and President, National Assembly and State Assembly, State Assembly, National Assembly and State. Now, the Supreme Court has always consistently, jealously restrict the application of this jurisdiction. One fundamental requirement is that the rights, the legal rights of the entity, either the federation or the state, must be the key issue in the case before the case can get to the Supreme Court in its original jurisdiction. We have had a number of cases where, for instance, in Plateau State and AG Federation, where the legal right that was involved was the legal right of the governor. And the action was instituted on behalf of the state. Similarly, in AG Anambra, AG Federation, a governor was trying to protect the tenure of his office and instituted an action in the name of the state. The Supreme Court said no. Those kind of cases cannot go to the Supreme Court in its original jurisdiction because the legal rights of the state were not involved. Also, we have had a case AG Federation, AG Lagos, where the AG Federation was trying to protect the interest of private citizens that purchase some properties of the federal government. The Supreme Court refused to assume jurisdiction because the legal right involved was not the legal right of the federation. And also, the implication of insisting that the legal right must be that of the federation or the state is that private persons or any other agency cannot be joined in an action going to the Supreme Court in its original jurisdiction. We have had instances where attempts had been made to do that. AG Ondo, AG Federation, where FEDECO in those days was joined with the federal government, and then it was said that no, you cannot do that. Once other agencies or other bodies, other persons are joined, the case necessarily moves out of the original jurisdiction of the Supreme Court. Now, Court of Appeal. There are 2 items here over which the court as original civil jurisdiction, whether somebody has been validly elected to the office of president or vice president, or whether the office of vice president or president or vice president has ceased, or the office has become vacant. The first item there has to do with election petition challenging the election to the office. The second item there has to do with the vacation or termination of the term of office of the occupier of the office. Now we have had a case of, we have several election petitions involving the office of the president or vice president. But the only case that I can't remember relating to the vacation of the office or whether the office has, the term of office has terminated or not is the Abubakar AG Federation then, the vice president then, on the issue of moving from one party to the other. And the question was whether he has also lost his right to remain in the office. That case had to go to the Court of Appeal in its original jurisdiction. Federal High Court. This is extensive. We'll just highlight some of the key issues, key areas here. For the first three items under Section 251, revenue of the Federation, taxation, customs, they are all matters that affect revenue of the federal government. And then revenue must be an issue, and then mostly often than not, federal government is a party to that suit. Yes. And then paragraph D, which is a bit contentious. Banking policy goes to the Federal High Court. No doubt about that. The major issue here is when it comes to customer banker transaction. We've had cases in the past that is either Federal High Court had jurisdiction within 251, which is exclusive, or it doesn't. So, but in NDIC and OKM Enterprises, the Supreme Court had come up with the position that the fact that customer banker transaction is not within the exclusive jurisdiction of Federal Court does not deprive Federal Court of jurisdiction. That only means that the jurisdiction will be concurrent. The practical implication of that today is that when it comes to banker customer transactions, the case can go to Federal High Court, can go to the State High Court, even in appropriate cases can go to the Magistrate Court, depending, even District Courts too, depending on the monetary value of the claim involved. So that is the position where we are now. Then when it comes to matters relating to KAMA, appointment of director, removal of directors and the rest of them, transfer of shares. But the problem here is that the issue must strictly involve construction and interpretation of KAMA. The fact that the company is engaged in a transaction does not make Federal Court to have jurisdiction. We have that the case of Tanariwa against Plastiform, to where the Court of Appeal insisted. The fact that the company is involved does not translate the matter into a matter under the jurisdiction of Federal Court. Intellectual property cases go to the Federal Court, but it must be remembered that those kind of cases must be those relating to rights created under statutes, like Trademark Acts, Copyright Acts. For instance, the Federal Court does not have jurisdiction over common law thought of passing off. We have cases on that. Admiralty jurisdiction of the Federal High Court. This cannot be really understood without reading the Admiralty Jurisdiction Act, which has set out the full ramifications of the jurisdiction of Federal High Court, and including the issue of ownership, leasing, and the rest of them. But this jurisdiction seems to overlap that of aviation because Admiralty Jurisdiction Act mentions not only ships, but also aircrafts. But when we talk about aviation, of course, definitely the issue of carriage of goods, carriage of persons, buy tickets, there's issue of failure to carry or damage to the to the baggage and the rest of them, we come within the aviation jurisdiction of the Federal High Court. And of course, damages caused by air accidents will come within the aviation jurisdiction of Federal High Court. And then lastly, before we leave this slide, the issue of jurisdiction of Federal High Court in relation to federal government agencies, federal governments and any of its agencies. We now realize, and that has been appear to be more settled, that it is not in all cases where federal government is involved that we go to Federal High Court. It is now clear that matters of simple contract cannot go to Federal High Court, even when the federal government or any of its agencies is involved as a party. Now, Federal High Court jurisdiction also includes issues of some political issues, like a term of office of governors and national and state lawmakers. We have pre-election matters. Section 84 read together with Section 285 of the Constitution. Somebody relating to primary elections and the rest of them go to Federal High Court. Then fundamental right cases will go to Federal High Court. However, this is not exclusive. In fact, there is serious forth and back in different decisions of the Supreme Court as to whether once a matter is fundamental right, it can go anywhere, or whether we have to take into account the subject matter giving rise to the fundamental right claim. In cases like Footman against Olutayo, as well as EFCC and REN, the Supreme Court came up with a decision that fundamental right cases stand above any other claim. And all the relevant courts, is it Federal High Court, State High Court, and actually NIC was also listed, particularly in EFCC and RENI. So as courts that with possible jurisdiction over fundamental right cases. But when we read cases like Wanzi and FRC, Adeton and IG Enterprises will come up with the conclusion that we cannot take a fundamental right action without considering the subject matter, the issues, the facts, giving rise to the fundamental right claim. And if, for instance, as occurred in Nwanze's case, the issue was employment, conduct of employment, there was the issue of breach of fundamental rights, and then there was an attempt to pursue the fundamental rights. Although this case can also be ascribed to the fact that the principal claim in that case was not a fundamental right, but rather termination of employment. But we have this case of Omidino that involving drug. That was a Court of Appeal decision that because of the fact that the cause of action, the principal case, or the fact that gave rise to the case was drug, that only Federal High Court could exercise jurisdiction over a fundamental right claim arising from that case. But if we go by Olutayo and EFCC and RENI, that may not be the case. And actually, as the Supreme Court said in EFCC and RENI, once fundamental right case, the fundamental right claim is the principal claim, that it doesn't matter what the subject matter that gave rise to the court and to the claim is. So these are the competing decisions. For me, as counsel, if I have a case, I would rather play safe and take into account all relevant considerations, including the fact and the subject matter that gave rise to the claim, in deciding which court I take my fundamental right action to avoid unnecessary arguments. Determining the appropriate court. NIC. Looking at Section 254C, very powerful provision that says, notwithstanding anything in Section 251, 272, 257, and the rest of them, NIC shall have exclusive jurisdiction in labor-related matters, and it includes a full ramification of issues, even including human trafficking, condition of service of entitlements of public officers, judicial officers, and the rest of them. So now the effect is that when any matter relates to labor or employment, industrial relations, no other court can go near the case. That would be the National Industrial Court. Now, State High Court, which include the Federal FCT High Court, Court of General Jurisdiction, actually the court that will say with the widest jurisdiction in Nigeria today, because everything is within the jurisdiction of those courts, except those items that have been exclusively given to some other courts like NIC, Federal High Court, and the rest of them. Election tribunals. These are courts that, as the name suggests, tribunals, they have exclusive jurisdiction over post-election matters. Which one do we go to? Depending on the office. If the office of the governor, then we have governorship election tribunal. And if it's that to do with lawmakers, we have national and state assembly election tribunals. And these tribunals have exclusive jurisdiction over election petitions, post-election cases. As we have said, pre-election matters are now within the exclusive jurisdiction of the Federal High Courts. We have magistrate and district courts, which are also courts of general jurisdiction, but again, matters that have been given to other courts are outside of their jurisdiction, and then title to land, the construction of wills are actually outside of their jurisdiction. They dare not go there. And then they are court of limited jurisdiction because monetarily their jurisdiction is limited. Now, before we go to file our case, after we have decided two issues, we have decided the cause of action, we have decided the court to go to. The next item for us to decide is how are we going to constitute the parties? Who will be the claimants or the plaintiffs, as the case may be, depending on the rules that we're using, or the petitioner or the applicants? Then, who are the defendants? We must realize that issue of parties may also go to jurisdiction, because when a necessary party is not before the court may not be able to exercise a jurisdiction. And then, most importantly, the parties we constitute must be those with capacity to sue and be sued. This can be very, very fatal, because if the sole claimant or the sole defendant happens to be a person or a non-person in law, of course, at the objection of the other side, or even so motivated by the court, the name will be struck out. And when the name is struck out and happens to be the sole claimant, there can't be a case in court without a claimant. That will be the end of the case. Now, who are the persons in law? We can be natural persons or artificial persons. For natural persons, all human beings have the right to go to court, but some have deficiencies. Some have to go through others. We have cases of people we say they're under legal disabilities, infants, for instance, or bankrupts and the rest of them. They have to go to court through their guardians. And then there are instances where a person may not be available to pursue his claim by himself. He may have to appoint an attorney by power of attorney. How do we constitute parties in that kind of a case? The law is that the case must still be constituted in the name of the donor, because if the case is constituted in the name of the attorney, the case is bound to be incompetent and be struck out. We have the case of Kofuakan gases and DIV, where the Supreme Court eventually struck out the case because the action was constituted in the name of the attorney. Then we have instances where personal representatives who will be suing on behalf of the estate of the deceased. How do we constitute the parties? The law is that the action must be constituted in the name of the individual, the human beings who are now the administrators or the executors, not in the name of the deceased, not in the office, not in the name of the office, the executor or administrator of the estate, as was done in the case of estate of Abacha and Ekespiv. So that would be incompetent. The action will be incompetent and be struck out. It's liable to be struck out. So what we can draw here is that when a person is still alive, the case must be constituted in his name, even when he's pursuing the action through the instrumentality of somebody else, like a guardian. The name of the infant must be the one as a party, followed by the suing through his guardian or whoever. And then, if it's an attorney, the name of the donor, that's Mr. So-and-so, suing through his attorney. So, but if once the person is dead, then such a person can no longer be the one to constitute the action in court in his name. Then we have artificial persons in different categories. We have corporation souls, like different offices that we have. The president of the Federal Republic of Nigeria is a name, is an office. And then IG, Inspector General of Police, Attorney General of the Federation or the state, those are corporations, so their offices, they are perpetually there. They can always be sued and be sued. And then we have corporation aggregate. Those are bodies that are either registered or directly created by statute. For instance, anybody registered by KAMA, like a company, for instance, is a juristic person, the power to sue and be sued. Yes, we have institutions created by statute, like even the CAC itself is a corporation. You have Council of Legal Education, you have bodies like that. But we need to see the statute creating such a body to know in which name to constitute an action. For instance, I use the case of law school now. The name that most people know is Nigerian Law School, but nobody can validly go to court in the name of Nigerian Law School, because that is not the juristic name of that body. It is the Council of Legal Education. So that is why it's always vital to look at the statute creating a particular body when we need to sue that body. And it's also of importance the fact that each statute creating a body may have some condition precedents that you have to satisfy before you can take such a body to court. Now, we also remember that firms or businesses that may not be juristic may also be sued in the name of the firm, subject to the fact that when the name is, the name of the person behind the business is known, then it can be joined. We have Ike Merchandise and then Pfizer, where a business name was sued and then there was an issue. Supreme Court said, yes, there's nothing wrong with that, because the rules of court actually permit that. And subject to the fact that when the name becomes known, the human beings behind the name, they are known, they can be joined. Then we have representative action, class action. We have Yusuf and Kindipe, where it has been said that when you have a large body of persons with common interest, as we have associations, whatever it is, but they are not juristic. The best they can do is to select one or two or few of them to sue in a representative capacity. And under the rules now, there's even no need for leave of court to institute action in a representative capacity. In most of the rules, Lagos, for instance, Abuja, and the rest of them. And then class action. This is developed very well in some jurisdictions, but we are still at infancy as far as Nigeria is concerned. The rules now allow us to institute actions in the name of a wide number of people whose identity may not even be known, because the rule says it's either the party members of the class affected by a particular cause of action, it's either they are not certain, or if they are certain, they cannot be found, or if they can be found, they are certain can be found, the court believes it to be more convenient to institute a class action, in which case a few people can be granted leave by court to pursue the action, and whatever remedy is granted will be to the benefit of every member of the class, who only need to identify themselves when they become aware of the case and the remedies which are available. Now, lastly, we have cases unknown persons. This is more like is most common in land matters, where squatters are involved and you do not know the identity of the person encroaching. Action can be commenced in the against the person unknown. However, when the unknown person knows himself, the proper step to take is to apply to join the suit, because we had the case against one person, and then on appeal, the unknown person wanted to appeal as a party. The court said no. Supreme Court, the best that can be done by such a person is to apply to for leave to appeal as an interested person, because the right stage to join is at the trial court, because once you know you are a party involved and you fall within the name unknown persons, and then you should apply to be joined as so that you can defend the case properly. Then the applicable rules. This, of course, we don't need to waste more time on this. It depends on the cause of action and the courts. For instance, if we're going to Federal High Court for winding up, these winding up rules that we apply. And then if minorities want to protect their rights, they may need to go through the company proceedings rules, which actually also prescribe the mode of commencement of action and whatever has to be done. And then you have fundamental right case. Federal High Court, what do? We use fundamental right enforcement procedure rules. So it depends on the court and the course of action that we are pursuing. Those are the things that will determine the law and the rules, particularly, that we're going to use. For instance, we are going to election tribunal. We have the first schedule to the Electoral Act. We have the Federal High Court rules, because the law says when there is no provision in the rules in the first schedule, then the rules of Federal High Court will apply, and then we have practice direction. So the various state high courts, you have the principal rules of court, we have the matrimonial cause rules, if that's the cause of action that we have, the first cases, the first proceedings, and therefore if we are going for fundamental right before those courts, then we use the FREP rules. So it depends on the cause of action that we are pursuing and before which court we are pursuing the claim, that will determine the rules that we adopt. And it's those rules that we describe or prescribe the steps we need to follow in pursuing our claim. Then, coming to the mode of commencement. Generally, we have four basic modes.
Sorry, Mr. Alimi, please forgive me, sir, for interrupting. Please, sir, I don't know if you can round up in within 5 to 10 minutes so we can go into the question and answer. I just want you to be mindful, sir.
How many minutes more so that I can time myself?
10 5 to 10 minutes. Fine.
Okay.
Well, we can stretch to 10.
Let me go for the larger figure. 10 minutes. Yes,
Okay.
Thank you, sir. Now, determining the mode of commencement. Basically 4 modes: writ of summons, originating summons, originating motion, or originating petition. How do we determine which mode to use? Most contentious, when you have contentious cases, the most widely commonly used mode is, of course, the writ of summons. And all our rules of courts seems to be on the same page on this. Even the National Industrial Court rules that mention a different name says complaint form 1. When we look at the form, we realize that it's an adaptation of the writ of summons, and that is the general mode. Then originating summons. When do we use originating summons? There are 2 circumstances when the law prescribes for the use of originating summons, because we have some instances where the rules or the law prescribe use of originating summons. If company proceedings rules, the general mode of commencing company proceedings is by originating summons. Ajib and Ezendu winding up petition, then we know what to do. But other than that, the general mode of commencement of company proceedings is by originating summons, is where, for interpretations of statutes or documents, where facts are not likely to be in contention, non-contentious matters. We have the case of Lawan and Machina, where the Supreme Court was able to identify the fact that fraud was pleaded, and the facts are likely to be contentious. Therefore, the proper mode of commencement should have been writ of summons and not originating summons. So, and we know that originating summons is faster. Yes, that's why people may want to go for it. Then originating motions, again, can only be used when it is prescribed by the rules. That's why for fundamental rights, it's prescribed. So it says, we check at the back of the prep rules. We see that the form there is actually originating some motion, although the rules itself says we can use any mode approved by the court. Then we have cases like prerogative remedies, Andermoon's injunction address of them. The forms prescribed there are originating motion, although the rules also allow the use of originating summons sometimes. Then we have petition. We have cases, these can also be used only where it is prescribed by the rules. For instance, matrimonial causes, we use a petition. For election matters, we use petition because those are the mode prescribed by the law for us. Now, preparing the originating summons or the originating processes. The first thing we need to do, having chosen the court and chosen the identify the cause of action, identify the cause, identify the mode of the parties and the rest of them. There may be need for us to take some pre-action protocol steps, and this is fundamental because when we are filing, for instance, in Lagos now, the pre-action protocol bundle must be filed as a separate bundle along with the originating processes that must also be contained in another bundle. So, and what are those pre-action protocol steps that must have been taken, that must have been exchange of correspondence with the potential defendant, so that for the review to see whether the matters can be resolved out of court. And if peradventure there's a failure of a negotiation or there's no settlement and you want to go to court, then you want to convince the court that you have taken necessary steps towards that direction. And that is why it is required as part of the document to be filed, to be front-loaded, that those pre-action protocol bundle must accompany the originating process. Then drafting of and endorsement of the originating processes. The standard court process, originating process will have the court, the parties, the claim, the address of parties. Now, of fundamental importance is that the signature of counsel and the seal. And we now know that the signature of counsel must be a counsel court to the bar, because anything other than that is vital. It actually goes to the jurisdiction of the court. Document that will need to accompany the originating process, depending on the mode of originating process that we have adopted. If we are using writ of summons, for instance, we must have a statement of claim, our list of witnesses, statement of oath of the witnesses, and then any document exhibit that we need to rely upon. And then depending on the jurisdiction, if it is Lagos High Court, for instance, now we have to have a pre-action protocol from one, as I mentioned earlier on, in the form of pre-action protocol bond prescribed by the practice direction. And then if it's at the Federal High Court, for instance, we must have an affidavit of non-multiplicity of proceedings. If it's Abuja FCT High Court, for instance, there is need for a certificate of pre-action counseling. So we need to examine the rules of the court before which we are commencing our action to know the kind of document that we need to package. And what we need to package will also depend on the mode of commencement, as I said earlier. Because if we are talking of winding up petition, for instance, apart from the petition itself, the verifying affidavit is a mandatory, and then there must be exhibits. And one vital exhibit in that kind of a case, if it's a winding up petition at the instance of the creditor, for instance, there must be a demand notice under the hand of the creditor. If that is missing, the case is likely to go nowhere, to be incompetent. If it's an election petition, apart from the petition itself, we need to accompany that with the list of witnesses that we're going to call, the statement on oath of the witnesses, any exhibits that we're going to use, address of them. So if it's a matrimonial causes, again, you need to accompany that with maybe verifying affidavits. We need to the certificate of conciliation, and the rest of them. Then fundamental rights, we have your the application, the originating application, the originating motion, along with the statement containing the facts, the grounds upon which, and the reliefs, and then the affidavit and written address. So, as I said, essentially, we need to examine the rules of the court and the course of action that we are going to court with, to know what we need to package as a way of our originating process. We have the fast track. All the courts, at least we have fast track procedures. In Lagos, for instance, the claim that come within that, and how do we proceed? There's no special procedure for this, other than the fact that when we know that our case qualifies, it's for the registrar to mark it qualified for fast track, that the liquidated sum of 100 million naira or more, and then or action relating to mortgages and charges. Then for FCT High Court, in fact, has a special division, the fast track division, with judges designated by the chief judge. So, and it is from 32, it is the party that will actually apply for the matter to be under the fast track. And then NIC too, matters relating to strike and industrial relations that may challenge or affect the peace and stability of our economy are matters that qualify for fast track. So once we know that, we also know that the president of the court can direct a matter to be on the fast track. So when we can take advantage of this window, once we know that our claim or our cases come within, because there are opportunity for fast tracking or getting a matter disposed of speedily. Now, concurrent originating summons, originating processes, it's really nothing, but it can be very useful when we have a number of defendants, some within jurisdiction, some outside. And then for those, we know Section 97 of the Sheriff and Civil Process Act requires that the endorsement on this originating process to be served outside of the jurisdiction. In that instance, we can use concurrent originating process, concurrent treat or originating summons, as the case may be. So the ones for defendant within jurisdiction will normally not require such endorsement. And then the one to be served outside jurisdiction can be so endorsed. So, but a concurrent originating summons or originating or writ of summons are nothing other than just like a counterpart. Before there was need for leave of court, before we can use or concurrent originating process, but now the rules allow a claimant to cause concurrent originating process to be issued without leave of court, at least for that process, for that purpose. Now, by way of conclusion, if peradventure we fail to comply with all those requirements relating to how to package our originating process or how to endorse our originating process, what do we need to do? We have different effects depending on the jurisdiction. For instance, in Lagos, under the Lagos High Court rules, if non-compliance has to do with the stage of commencement of proceedings, those processes to be packaged. If any of them is missing, the rule is that it will be fatal to the case, because it will render the originating process a nullity. Other jurisdictions, Abuja High Court rules, NIC rules, Federal High Court rules, require that all those failures are nothing but mere irregularities that can be regularized. But the fact that those jurisdictions also mention irregularities should not give us the false sense of hope that non-compliance may not be fatal to our case. For instance, we mentioned the case of somebody that has a winding up proceedings and omitted to accompany his process with a demand notice under the hand of the creditor. That would be vital. That can render the entire case incompetent. And then we also mentioned the case of signature, mere signature of counsel on the originating process can render the originating process a nullity, regardless of the provisions of the rules. So we need, as counsel, we need to pay close attention to how we identify our course of action, how we choose our courts, how we choose our mode of originating process. As we have seen, the case of Lava Machina ended up being resolved on the mode of commencement of the proceedings. So, and those are all the issues that we need to have at the back of our mind, even before we take our matter to court at all. So thank you so much for listening.
Thank you so much, Mr. Alimi. I mean, I know it's a very extensive topic, and so but I think in the short time allotted, you've been able to at least deal with a lot of very, very important issues. I think I thank you for a very, very good presentation. I think we'll go to the question and answer session straight away. I hand over to my colleague, Mrs. Okireke. I urge our colleagues to post their questions in the Q&A box provided on the screen. Abby, are you there? Mrs. Okireke.
Yes, I am, Tio. Thank you very much, Mr. And indeed, Tio, we have more than enough questions here already. Samson Osondu says, please, in what situation where a claimant wishes to sue both a federal agency and a private individual as defendants in a matter that is not simple contract, can the claimant initiate the suit at the Federal High Court or the State High Court?
The answer to that is that the case goes to Federal High Court. That is not contestable, because once the agency of federal government is involved, and the matter involves administrative or executive action of that federal government agency, and as the question suggests, that it is not a matter of simple contract, then the matter goes to Federal High Court, regardless of the joinder of a private person. The determining factor in that to be the presence of the agency of federal government as executive function. So that is what will take the matter to federal.
Thank you, sir.
I hope that answers the question.
Thank you. Temitope Olajuwon says, kindly explain the difference between. Can you hear me, sir? We can hear you. I don't know if you can hear me.
Did you hear me? You are frozen for a while.
Yes.
I can hear you now. Were you hearing me?
Yes, we heard you. We heard you. Thank you very much.
You are frozen again, no?
Hello, Mr. Alimi, can you hear us? Hello.
Is it my network or yours?
I think it's your network. I think. Well, I can hear you now. Hello, Mr. Alimi, can you hear me?
Is it my network or yours?
It appears it's your network, sir.
I can hear you now.
Okay. Yes, I can hear you.
Okay. There's another question here. It says, where a captain of a vessel is owed his wages, what court has jurisdiction to handle his claims in view of Section 254C and the Admiralty jurisdiction?
What's the question again?
Where a captain of a vessel is owed his wages,
okay,
what court has jurisdiction to handle his claims in view of Section 254C and the Admiralty jurisdiction?
I would rather believe that the principal subject matter in that case is Admiralty. His contract of employment will be Admiralty, because I know if we read the provisions of Admiralty Jurisdictions Act, supplies and the rest of them, provision of service, contract of service and the rest of them to the ship falls within Admiralty jurisdiction. So in that case, I don't think it will be a simple matter of contract. It's very, very likely to fall within the Admiralty jurisdiction of the Federal Court. However, the issue now is, in view of Section 254C that says, and notwithstanding, that is a problem. Notwithstanding anything in Section 251 or any other provision of the Constitution, when it comes to employment, then it goes to NIC. So with that, with the provision of the imperious nature of 254C, I think once labor is involved, it's likely to go to National Industrial Court because of the wording of 254C. That's my humble view.
Thank you, sir. There's another one here from Temitope Olajuwon, and it says, kindly explain the difference between the Federation and the Federal Republic.
Is a contentious one. You know, we have had cases when the court has to, this actually has to do with the original jurisdiction of the federal, of the Supreme Court. You know, if you look at the Constitution 232, talks about federation and states. And the question now is, excuse me, where an agency of the federal government is involved. That is because that is federal government. Federation means the entire country as a whole, as a unit, not an agency of federal government. And for instance, I think there was this case of, was it AG Federation and AG Lagos, where the Supreme Court said that FIRS that was sued, that there was a dispute between Lagos State government and FIRS. Eventually, Lagos State government took AG Federation to court at the Supreme Court. The question was, the issue involved in this case, is it a matter that involves a federation or an agent or federal government? The Supreme Court said, in that case, what was involved was an issue involving federal government, because FIRS happens to be an agency of the federal government, and that the issue is not one involving federation as an entity. So it may be a bit difficult to draw the line, but I think what they are trying to say is that before a matter can go to the Supreme Court in its original jurisdiction, the legal right of the federation as an entity, as opposed to federal government or any of its agencies, must be involved. So where the issue involved is one of federal government or any of its agencies, then federal government cannot step in and use that to go to the Supreme Court. And no state can also use that to take federation to the court. So there's that distinction between what belongs to the federal government and what belongs to federation. Federation is actually all of us, including the states together. Whereas federal government is a unit of government just like any of the states. I don't know whether I'm making any sense, or whether the person that asked that question is following the line of distinction. It seems not to be that clear, but at least by reading, it's a 2014 decision of the Supreme Court, AG Federation, AG Lagos and AG Federation, where they try to draw that line between federal government and federation, because the language used by the Constitution is actually the federation, not federal government. Meanwhile, if you look at Section 251, it uses federal government or any of its agencies. So are we saying the two provisions mean the same thing? No, the lawmakers must be understood to try to say different things.
Thank you very much, sir. I'm trying.
In one context, federal government now. What is involved is federal government. Okay, thank you.
Thank you very much, sir, for the answer. We have loads of questions.
Are you there?
Here. Yes, I heard you, and I was saying thank you very much, sir. We have another one here from Umar, and he says, "Thank you for your input on persons unknown. How should a party sued as persons unknown enter appearance and defend the suit?"
It only needs to apply to join.
Can someone who has no letter of administration for a deceased be sued as a defendant? That is, a legal representative of a deceased.
The way you can do that, or that can be done, is to sue in a representative, to sue that person in a representative capacity, in which case you sue him for himself and as representative of the beneficiaries of the estate. So if you have issues relating to maybe the beneficiaries or the deceased, when it has to do with proprietary matters, you cannot sue somebody ordinarily who is not an administrator or executor, but that person can be sued in a representative capacity, I believe.
Thank you. Patrick says, can a company donate power of attorney to a natural person to sue on its behalf?
Yes, it's possible. The company is a person in law, and whatever a human being can do, to a large extent, can also be done by a company.
This person says, thank you for the educative session. Please re-explain the concept of concurrent originating processes.
Concurrent originating process simply means like a counterpart of a document. To all intent and purposes, concurrent read, for instance, let's stick to read. A concurrent read, to all intent and purposes, is identical to the original read. However, if you look at the rules of court that says we can use concurrent read along with for service outside jurisdiction, along with one for service within jurisdiction, or we can use a concurrent read for service within jurisdiction along with an original read for service outside jurisdiction. So the context where we use concurrent read more is when you have more than one defendant that are located or resident in different jurisdictions. For instance, you have two defendants. You are going to Lagos High Court. One of the defendants is in Lagos. Another one is in Ogun State or elsewhere. Normally, when you issue that writ, Section 97 of the Civil and Civil Process Act provides that any writ that you need to serve outside jurisdiction must be endorsed. This writ is issued within so and so place for service in the so and so state. So if the original writ is issued for service within the state, and you want to serve that same writ outside of the state, you need to issue a concurrent writ. And that concurrent writ will now be marked for service outside jurisdiction concurrent, then you endorse it in accordance with Section 97. And if you want to issue the principal writ to be the one to be served outside of the state, in that case, you need a concurrent writ that you will serve with those of the defendants that are within the state. But all
Thank
the same document.
Thank you.
Yes.
Page A. Bamayi says, thank you for your presentation, sir. What is the appropriate mode of commencing an action where the counsel is confused or not sure?
Now, confusion of counsel is one thing. Non-existence of a specific mode of commencement is another. If there are laws or rules that are prescribed specific mode of commencing a particular action. A counsel does not have a choice. You have to adopt that mode. And lack of knowledge or uncertainty of counsel cannot make a difference. However, where there is no specific law prescribing a particular mode of commencing a particular action, and then the counsel is now not sure of what mode to adopt, then the default mode of commencing an action, as far as the high courts are concerned, is the writ of summons.
Thank you. There are two similar questions here. One says, how can a known person be sued? And then another one, can an unknown person appeal?
Now, an unknown person can be sued. For instance, as we have said earlier on, in fact, under the Lagos High Court rules, we have provision for recovery of premises for squatters, from squatters. And you know, it is quite possible that you may not actually know the identity of those encroaching or squatting on the land. For the purpose of recovering the land from such people, you can sue the occupiers. That is similar to suing unknown persons. You have a piece of land, people are encroaching, you know some of them, you don't know others. You join the name of those that you know, you just had unknown persons, so that if anybody believes that is interested in the property, the ideal thing is leave will be obtained to serve by substituted means by posting the originating processes on the premises or the property, the landed property involved, so that whoever believes is interested in that property will come to court and contest the case. And when as somebody
we are losing you, Mr. Alimi. We can't hear you.
interest,
I think you're okay, you're back.
Of the court, and then in which case I was logged out. I'm back.
All right.
Yeah,
we'll just take the last one and then we'll just call
okay.
it.
No.
Thank you very much.
What was the last? So what was the last thing I said that you heard, so that I can repeat myself? We were talking
Can
of
you hear
the
me?
person. Yeah, I can hear you. I think we are discussing we are talking about the unknown person, whether an unknown person can appeal. I think the Supreme Court has said an unknown person cannot appeal as of right. He can only appeal as an interested person. That the stage at which the unknown person could have made himself known will be at the trial court. So if he doesn't do that, he can no longer come at the Supreme Court or the Court of Appeal and say he wants to appeal as a party to the suit. No, he can only appeal but as an interested party, and he needs to apply for leave for that purpose.
Thank you very much, Ms. Alimi. We're grateful for your time. We have a lot of questions here and also a lot of appreciation from our participants. I'll take Musa Amele Emmanuel. It says, the two presentations were brain refreshing. Kudos to the organizers. And on this note, I'd like to say thank you to you on behalf of the NBICLE. Tio, over to you, please. Thank you very much.
Thank you very much. Thank you very much, Mr. Alimi, once again for this presentation. I mean, as I said, obviously a lot of work and thinking and research went into it. There are a lot of things that we lawyers sometimes we take for granted. Even today, they're basic. I think the takeaway from your presentation is just the need for the lawyer to be painstaking to cross his T's or T's and dot the I's, and just be very thorough. And you broke everything down, and as did Mr. Sule as well. Just today, there's a matter that has just been, we didn't commence it in my office, but it was the client is referring the matter to us, and we were just reviewing the case file. And there are almost at trial, or they're already at trial. I mean, they're almost at trial. Almost at trial, we discovered that there was a arbitration clause in the agreement, which was never invoked, and which would have been very important to the client, considering the client's strategy and what the client is seeking to achieve. And unfortunately, we cannot even raise it anymore because arbitration, by its very nature, once you file processes, you file the defense, you are deemed to have waived the option to go to arbitration. So, I mean, this, as you said when you started your paper, I think in beginning your action, you just have to think through everything. You should have a long view, a broad picture of the entire case, and all these key issues that you raised, that Mr. Sule raised, need to be sorted out, because you can make an error that will just derail your entire strategy going forward. So thank you very much. Thank you for the questions. And we still have a lot of questions. I'm seeing about 47 questions in the Q&A, but we can't, unfortunately, we cannot take all these questions. We are going to share the slides for today's presentation. So please bear with us. Tomorrow we have 2 sessions tomorrow. We're delving into I want to thank Mr. Alibi again very, very much for the presentation. It was very profitable. I mean, I learned from it too. We have 2 sessions tomorrow. Our first session is on pleading. So we are delving into pleadings, which, I mean, pleading is a very important part of our work. It's a very important skill. And it's not, I mean, like we said today, like Mr. Alimi explained, you just don't grab your pen or grab your laptop and start typing pleadings. There's a lot of thinking and process that goes into thinking through the pleadings and putting it together properly. Luckily, we have like today, we also have a very strong faculty. We have very strong speakers tomorrow. We have Mr. Eric Oban Sugbe, King's Counsel, Senior Advocate of Nigeria, who will be taking us through pleadings. We also have Mr. Sebastian Horn, SAN, who will be taking us through the supporting evidence required when you are putting your case together, how to put the evidence together and all that. Of course, we were having a conversation in my office, I think it was last week or earlier this week, and the joke was that Mr. Horn's book on evidence is the most widely used practice book on evidence today. It seems. I mean, that's what some of my colleagues think. And so it will be a great pleasure to have him also taking us on preparing our evidence. And then we also have pleadings tomorrow. We enjoin our colleagues to join, and we also enjoin you to encourage as many of our other colleagues who were not able to join tomorrow. Tomorrow promises to be very explosive, very good presentation. We have a lot to learn from these 2 gentlemen. And I encourage us to join and to encourage as many of our colleagues as possible to join. I thank all those who participated today. I thank members of the faculty who logged in. I thank the speakers, and I thank all our colleagues who are delegates who registered for this conference, who attended and who have asked questions and positive feedback. Thank you all very, very, very much. I wish everyone a pleasant evening.